Welcome back to Winning Isn't Easy. What every ERISA policy or plan holder needs to know about the role of a vocational expert in their disability insurance claim. Your ERISA disability insurance carrier or your plan doesn't make it easy for you to get your benefits. You might have to file an appeal of a denied claim or terminated benefits. And in many cases, the disability carrier or plan has had your case reviewed by their in-house liar for hire vocational evaluators. These people are there for a reason, and that is to create a justification to allow the disability carrier to deny your claim or terminate your benefits. It's a game. So what is the game? Number one, the first question they are going to be asking in their analysis is, what is your residual functional capacity? Now, often a carrier or plan's liar for hire doctors will disagree with your doctor about your functional restrictions and limitations. That isn't to say your doctor can't help. I think your residual functional capacity forms are crucial, and they are, in my view, an adjunct to attending physician statement forms. These forms will help address what you can do or not do physically, cognitively, and psychiatrically in the work setting. I think that the carrier plan should be considering all of your medical symptoms in determining your residual functional capacity. That's not often the case. The vocational evaluators are going to be relying on the liar for hire doctor's opinion about your residual functional capacity form. I don't think I've ever seen the disability carrier plan give to the vocational evaluator the opinion of the claimant's actual treating physicians. So that's one of the first points of disagreement. What, in fact, are your functional restrictions and limitations from each one of your medical conditions and then collectively? Once this process is started, the vocational evaluator is going to take whatever residual functional capacity the carrier or plans adjuster says to use. And then they're going to sort your physical or cognitive or psychiatric restrictions and limitations. Primarily, they're going to start with the physical residual functional capacity form. They're going to sort it into very heavy, medium, light, and sedentary work. So they're going to say, okay, well, you can do very heavy work. Now we're going to compare that to the strength level of your past occupation. And that is also a point of disagreement. So we've got a disagreement on the level of your post-disability residual functional capacity. Number two, we have a disagreement about what your occupation might be in a strength level. And number three, we have a disagreement as to how that vocational evaluator has classified the nature of your past work and your future capabilities. That leads me to topic number two. What is the strength level of your past occupation? Now, the disability insurance carrier plan, Social Security Administration, they all use something called the Dictionary of Occupational Titles in their analysis. The DOT, which is published by the United States Department of Labor, is a reference guide that provides detailed information about jobs in the United States. The problem is that the DOT hasn't been updated since the 90s. So you can imagine that it is out of date. But nonetheless, many disability insurance policies or plans will say you got to use the Dictionary of Occupational Titles. How stupid. But it is what it is. Now, for each job, the DOT is going to provide a job title, a brief description of the tasks and duties, the strength level of the job, and the specific vocational preparation it takes to learn that job. The vocational evaluator is going to review your work history and, based on your description, determine which DOT code most accurately describes the work you did. So they're going to try to pigeonhole you. Then the VE is going to identify the applicable job title, the strength level based on the DOT, which does address strength level and specific vocational preparation, and convert it into your job into an occupation. Now, there's a problem there because how you perform it may not be the same way that the DOT describes it. And that can be a huge issue in these cases. And again, depending on the terms of the policy or the plan. Remember, you insure your occupation and not your job. And in my view, there's a problem many times with the VE's conversion of a job, quote unquote, into an occupation. The third thing that we want to talk about is what kind of skills you learned in your past occupation. As I've said, the disability carrier plan is going to use the DOT to determine the level and nature of the skills you've learned in your past occupation. They're going to be classifying your work based on the Dictionary of Occupational Titles. There's unskilled work, semi-skilled work, and skilled work. And the VE, using a computer program, is going to identify the skills and specific vocational preparations required in your past occupation, first to determine if you can still do your past occupation, and then at the any occupation stage, if that's where we're at, whether you can do any other occupation in view of your residual functional capacity as they've determined it and the transferable skills as they've determined it. That's where lots of games are played. Let's say you are at the any occupation stage of the claim. You've been paid own occupation benefits probably for 2 years. Now the definition has changed to an inability to do any occupation. Again, you've got to look at the terms of your disability policy or plan for that definition of any occupation. Now I'm going to dig into the VE weeds, if you will, a little bit, but bear with me. The DOT, as I've said, will classify occupations or work based on skill level. Semi-skilled work is a job that requires basic training or experience and can be learned in 3 to 6 months. And common examples of this include operating a machine, doing assembly work, or doing routine tasks using hands and feet. A semi-skilled worker can carry out duties without the help of a supervisor and doesn't really require any specialized training. Now, if the carrier plan says that you can do semi-skilled work as they're denying or terminating your benefits, the question really becomes whether, based on your residual functional capacity, you can really take those skills to other occupations as that term is defined. So let me give you an example. Let's say you were a machine operator at the time you became disabled. And the question is whether you can do that occupation, the own occupation stage, and then at the any occupation stage, whether you've learned any skills that could be transferred to other work, such as assembly work, in view of your residual functional capacity. Now, if you have transferable skills to semi-skilled work, generally you would not be considered disabled under the terms of most disability policies or plans. Let's talk about skilled work. That refers to jobs that require training or education in a particular field through formal education or on-the-job training. Now, skilled work requires training involving complex tasks and difficult decisions. So my profession as a lawyer is classified under the Dictionary of Occupational Titles as skilled work because I have an advanced education and my work requires very specific skills. I have to deal with people, facts, figures, analyze situations, present ideas and arguments, and I have to be able to negotiate and stand on my feet and think quickly in a trial setting. At the own occupation stage, the question would be whether I'm capable of doing my past occupation as an attorney. But at the any occupation stage, the question is whether I've learned any skills that I could take to any other occupation in view of my residual functional capacity. Now, often the higher the skill, the less likely it is it's going to transfer to other skills. So in my example, I wouldn't necessarily have the skills to be a paralegal. I could supervise a paralegal because what a paralegal does is completely different from what a lawyer does. But I will tell you that is often this transferability of skills is often a point of disagreement and needs to be raised in an appeal involving denied or terminated benefits. I will tell you that many times disability carriers, liar for hire doctors, and liar for hire vocational evaluators are applying a cookie cutter approach. They're not really looking at reality. Your case is different from everybody else's. And I think that the carrier or the plan should take into consideration all of your medical conditions, individually and collectively, in determining your residual functional capacity, and then address at the own occupation stage whether you can do that own occupation. At the any occupation stage, it's the transferability of skills to other occupations, I think, that is crucial and often where the errors are made. I will tell you that the VE analysis is a cookie cutter approach. And again, that is really where it should be attacked. Now, I think, again, that having an experienced ERISA disability attorney is really crucial because obviously this is pretty complex. I don't think this is something, quite frankly, that the average claimant or plan beneficiary can handle. So in our next segment, I'm going to talk about why you need an experienced ERISA disability attorney to address these vocational issues. Remember, if your claim has been denied or benefits terminated, you only have 180 days in which to file an appeal. And that appeal is the trial of your case. Got it? Let's take a break.